What's up guys? This video will talk about Section 5 of the Negotiable Instruments Law. Section 5 is about the additional provisions, not affecting negotiability. It states that an instrument which contains an order or promise to do any act, in addition to the payment of money, is not negotiable. But the negotiable character of an instrument otherwise negotiable, is not affected by a provision which first, authorizes the sale of collateral securities, in case the instrument be not paid at maturity, or, second, authorizes a confession of judgment, if the instrument be not paid at maturity, or, third, waives the benefit of any law, intended for the advantage or protection of the obligor, or, lastly, gives the holder an election to require something to be done, in lieu of payment of money. But nothing in this section shall validate any provision or stipulation, otherwise illegal. So, what is the general rule on this section? The general rule is that an instrument must not contain an order or promise to do any act, in addition to the payment of money. Otherwise, the instrument wouldn't be negotiable. In the promise to furnish additional security, a promise of the maker to render additional collateral will render the note non-negotiable, as that would be an additional act to the promise to pay money. However, they are to be distinguished from those instruments in which the holder may demand collateral, and failure to furnish it accelerates the instrument, which are clearly negotiable, but merely accelerable, on the non-performance of an optional act. Let us now go through the 4 exceptions to the general rule. First is the sale of collateral securities. In the sale of collateral securities, sometimes, the obligation arising from the transaction which gives rise to the instrument is secured by a mortgage or pledge. The additional act to be performed is to be executed after the date of maturity, when the instrument ceases to be negotiable in the full commercial sense. Before date of maturity, however, the sale of collateral securities would render the instrument non-negotiable. Next is the confession of judgment. The confession of judgment must be after the date of maturity, and is the second exception to the rule. There are 2 classes of confession of judgment. First is the cognovit actionem. It is a written confession of an action by the defendant, subscribed but not sealed, and irrevocably authorizing any attorney of any court of record to confess judgment in issue. Execution usually for the sum named. It is given in order to save expense, and differs from a warrant of attorney, which is given to an expressly designated attorney before the commencement of any action, and is under seal. Second, is the confession relict verification. It is a confession of judgment made after plea is pleaded. A warrant of attorney is an instrument in writing, addressed to one or more attorneys named therein, authorizing them, generally to appear in court, or in some specified court on behalf of the person giving it, and to confess judgment in favor of some particular person named therein, in an action for debt. Let us now move to the effect of confession of judgment in the Philippines. In the Philippines, a confession of judgment is considered void as it is against public policy. It is because they enlarge the field for fraud. Also under this treatment, the promissory bargains away his right to a day in court. And the effect of the instrument is to strike down the right to appeal accorded by a statute. The first 2 exceptions are done, let us now move to the 3rd exception. The 3rd exception to the general rule is the waiver of benefit. In this exception, it simply waives the benefit of any law intended for the advantage and protection of the obligor. Examples are presentment for payment, notice of dishonor, and protest. Last exception is the election of holder to require some other act. In this 4th exception, even if there is an additional act, the instrument still remains to be negotiable, provided that the right to choose between payment of money or the performance of the additional act is in the hands of the holder. And we are done. Thank you for listening guys. Have a good day. This video is made possible by